objective subjects, material latent defects, and the impact of the landowner. Oh yes, Howard asked me to talk a little bit about the Landowner Transparency Act as well. So anyways, next screen, Howard. So this is my contact. If you write down that, this is the number, this is my cell phone number. If you were to, in the middle of a negotiation, you got something weird you want to look at, sometimes it's enough for me just to get the contact and you send me a text, but make sure that you indicate that this is so-and-so, I'm from Grand Central, and Howard either sent me or I saw your presentation with Grand Central, and then text me your business card so I know it's you guys, and therefore then it's not somebody out of the blue. Now also, this is my cell number, so you can add this. I have the WeChat code right on the code, but text me is better, and WhatsApp as well, okay? But this is not for clients, this is for agents. So you need help and you need to do something, then you can get a hold of me, okay? So next screen, Howard. So I want to talk a little bit about objective subject clauses, because you have subjects and you write down subject clauses all the time. But it's important to know that when it comes to the idea of whether or not someone can back out of a contract, it's good to know a little bit about what what it means in terms of what objective versus subject versus mixed objective and subjective conditions precedent or subject clauses. So the next screen, Howard. So the idea is that can or cannot, and then the idea is we're using feng shui as an example, but in general, what are the ways in which a seller or buyer can back out of an accepted offer, okay? And it's using feng shui as an example. So, okay, next screen, Howard. So there's a couple of ways, and one of the ones I want to talk about are conditions precedents that are too subjective. And second, material latent defects. Okay, so and then I want to go through each of these in two different parts. So next screen, Howard.
Yeah.
So I wanted to give a case, just something I drafted up, so that you can highlight some of the topics as it comes up. So imagine in the seller's market where the prices are rising and the canceled contract can allow the seller to sell it for a higher price if they can find a way to back out. But the seller is eager to sell. And then you have a buyer who's desperate to buy, but is very, very conscious of feng shui. So you have that scenario where, and I don't have a sample contract, but just pretend these are the bullet points of the sample contract to illustrate some of the principles. The contract has only one subject condition, subject to approval by the buyer's lawyer. The buyer is very conscious of feng shui and specifically tells the buyer's realtor, who makes an inquiry with the seller's realtor. The seller's realtor, he dabbles in feng shui. He thinks he's pretty good, and it says, hey, no worries, good feng shui. It's facing west, good for everybody. Hey, don't worry. And the seller, though, had hired a feng shui guy named Jerry to do an assessment. And had really told the seller, but the seller didn't tell the realtor. Only a fool would live in the home, but they didn't tell the realtor that, okay? And then after subjects were removed, the purchaser discovers that the property has really bad feng shui and wants to back out of the contract. Okay, so next clause. So the first thing is, in a contract where it has the words that are considered too subjective by the courts, such as approval by the lawyer. Before the subjects are removed, the seller can legitimately, these are based on every lot of context, but they can say, hey, approval by the lawyer is too subjective of a conditions precedent. And therefore, before the subjects are removed, the seller can back out, even though the buyer has accepted the contract with conditions. Because the courts think that, well, this is really a revocable offer. It's not really a binding contract yet. And even if they're subjects, they can even back out, even though the buyer has accepted. And the reason, and I want to go a little bit about what does that mean? What does a too subjective clause mean? So the idea is that, well, what are the bases upon which a lawyer can disapprove of a contract? You have no way of knowing. There's no standard, nothing in which anyone can look at to see whether or not a lawyer can choose to accept or give advice to the buyer about what to accept or not. In those situations, it could be anything. It could be basically it'd be considered completely up to the discretion of the lawyer as to what they want to choose to has as a basis, a reason, a ground to accept it or not, approve the contract or not. So in the courts, they think that's too subjective. It's unknown. It's too ambiguous, too unpredictable. So if you go to the next screen, Howard. So this is the case that I want, and if you read it, it's like it's not that long. It's only like what 19, 20 pages, but it has all these facts that are really important to illustrate this principle. In this case, Zhang versus GNR Properties, the 2006 BC Supreme Court case, the buyer had wanted to buy a golf course and wrote down an offer. The realtor wrote an offer with 6 conditions precedents. Some of them ones are the usual ones, like subject to financing, subject to a few other things, but 2 of the subjects were considered too vague by the courts, that had no meaning. And so without the other subjects had been met, because there's financing that was met, and I think there was a few other ones, but these 2 are like, well, what do they mean? So next screen, Howard. Yeah, so I highlighted the 2 subject conditions, which the courts found were too subjective to mean anything, which allowed the seller to back out. Subject to the lawyer's approval by the certain date, and subject to accountant's approval by June 10th. So there's no way to measure or determine or have an assessment of what is being looked at or what is not being looked at by an accountant or lawyer. And in that situation, the courts said, hey, in that situation, the seller backed out of selling. The buyer sued the developer to try to force them to sell it. And the courts ruled that, hey, it wasn't never a binding contract, even if it was waiting for the buyer to remove it. It's not really, the seller can still back out because of the subject conditions being too subjective. If you go to the next clause, next slide, Howard.
Ivan, but one more question. If we were to put down subject to the lawyer's approval of this contract of purchase and sale, would that be better?
It'd probably be the same thing, because they have no idea what the lawyer is gonna what basis, the grounds upon which they're gonna approve or disapprove. They're gonna look at the formatting. Is it the context? Is it the terms? Is it the parties? There's no way. And the courts would say, and of course, the way you word it, and I have certain ways to word certain conditions, precedent clauses to make us what looks like subjective more objective, and we'll get to that later. Okay, but if it's subject to something approval, well, subject to a feng shui master's approval, that's also too subjective. There's no way to know. You choose one guy who'll say something and choose another guy something else. Okay. So next, so then I'm going to introduce the idea of 3 different kinds of conditions precedent or subject clauses. Objective is one of them because they are clear and precise. There's an obvious way of knowing, and everybody can tell what is and what is not applicable or not. So, for example, in this situation, subject to confirmation that the tenants have vacated the property by a certain date. The tenants are either in or they're out. There's no if or but or what, and trying to figure out, well, what if the tenants' suitcases are out, but the 1 foot in, 1 foot out? No, they're gone or they're in. So that's a very clear, subjective, not objective, and precise condition precedent clause. There's no ambiguity there about what could not be a condition to be met. So the next one, Howard, subjective, because if it's too subjective, this is what you want to avoid. If you want of course, if you're acting on behalf of the seller and you want to find a way to back out, that may be different, right? So subjective because satisfaction of that condition depends entirely on the state of mind of the purchaser, or whoever it is that's meant for it to be approving of. You like it, you don't like it, sure, there's nothing. So here, in such a case, the courts consider that the clauses in the contract do not create a binding agreement, but constitutes a standing or revocable offer that the seller can revoke and walk away from. There is no obligation to act in good faith to remove that clause on behalf of the buyer, but it's also too ambiguous for the seller to know that there's something they can depend upon for the buyer to do, and they can walk away as well. Okay, and then subject to approval or subject to the purchaser's total discretion is an extreme example of something like that. So, but then there's a third type, which is a mix between the two. So you can go to the next one, partly objective and partly subjective, which means that the parties have to take reasonable steps to fulfill the terms. So if you say subjective financing and you put down certain amounts of amount, like $200,000 at an interest rate of 3%, that puts an objective component to the idea that the person has to get a mortgage. It's not whatever mortgage that suits their satisfaction. If they are to get a mortgage approved within the whatever the contract sets, they have to go through with it. It's not like subject to a satisfactory mortgage approved that the buyer received. It's not like that. So here, there is an expectation that the buyer would take reasonable steps to get and fulfill that condition, and they can't back out if they need it. Okay. So, and the idea is that in feng shui, oh, sorry, where are we? Are you able to are you able to set the share screen? Allow me to run it yet? Or?
No, I haven't. Yeah, I think probably I have to work on the.
Okay, yeah. No, next time, no worries. Where I'll just go ahead. So the idea that can you back up one more? Back up.
Okay.
Back up one. So I just want to go on to the next one. So this is this is what you want in terms of if you have a subject one, you add some objective ways of determining something in order to make it something binding. Okay, so subjective terms. Now, if you use a sample of feng shui, and I'll tell you how to do that later, if you plan to use feng shui as a subject condition for a client of yours. Okay, so next one. So we have a scenario before subject removal. If the buyer, if she wanted to use a bad feng shui reading that she had to back out based on our scenario, they should have added that term to the contract. You notice how there was only, in our scenario, the only condition was that the lawyers approve it. Okay, and the lawyer is not feng shui master. Although I do read the books, and I can give a pretty good feng shui reading myself, but I'm just dabbling it. But I'm putting on a different hat. I'm a lawyer hat versus a feng shui hat. Anyways, I read a few books and I like it, but I'm not a feng shui guy. Anyways, if the buyer had really wanted it, you as a realtor representing the buyer should put it right into the contract to make it a condition and make it something objective as well. And I'll show you how to do that later. But in this situation, the fact pattern that I gave you, the seller can back out because the subjects were too vague and ambiguous. Because the buyer didn't specify that feng shui inspection was needed, she cannot back out using that reason. Okay, next screen. But even if you put in something like a satisfactory feng shui condition or inspection or assessment, or using those kinds of words, it still may be considered too subjective to have any meaning. So that may still be grounds upon which the seller can back out, and the buyer can't enforce or make the seller continue with the contract. But here's how you can add something to something subjective to make it objective, just similar to how we did that with the mortgage. Satisfactory mortgage, but you put down numbers like how much thousands and how much percentage interest rate. Oh,
sorry, it's my fault. I touched my.
Oh, okay, sorry, it's okay. We got one goes up, go slower.
My fault, guys. I'm sorry.
No worries. We're gonna get down to one more down there, right there. One more up.
Yeah.
There, stay, yeah, perfect. So on the second bullet point is that, quite often when you have a feng shui reading, they say that sometimes, oh, you should build a driveway so that you can enter the house through the west or the east. Or you have to put a tree up in order to block the bad feng shui, that's the qi that's coming into the house. So here's what you can do. You put a dollar amount for whatever it takes in order to rectify whatever deficiencies that the feng shui assessment gives. So for example, and this is the sample that I give here, subject to a professional feng shui assessment, where the total value of improvements needed to rectify feng shui deficiencies exceeds 500. So that, then you need a two-part to this. If the feng shui assessment reading comes up with, oh, all you need to do is put a plant by the stairwell, or put a aquarium tank right by the back door or patio, okay, it's not going to cost $500, and then you have to go through with it because it didn't exceed $500 to fix whatever needs to be done according to the feng shui. So this is adding an objective component necessarily maybe considered a too subjective type of a thing called a feng shui reading. Okay, go to the next screen. This is a situation where given the fact pattern that we have, where the buyer specifically makes a verbal request to the seller's agent about the feng shui, and the seller's agent represented something to the buyer, and then the buyer went ahead. Okay. Now there's potential for the fact that the buyer can still back out, and this is how you point this out. And this is scenario 3. The purchaser can still try to back out by pointing out that the seller made a misrepresentation on something called a material latent defect. This is different from a latent defect, and also different from a patent defect. And this is where I want to talk about that topic now. Next one. Okay, so what is the difference between patent latent and material latent defects? And the main thing is really, as realtors, you have practically a bigger standard and higher onus of representations that you have to deal with than even the landowner themselves. Okay, so next phase, I want to talk about these topics. What is a patent latent defect? What is a latent defect? What is and how is that different than any material latent defects? Okay, so move on to the next screen. Oh, next screen, Howard. Yeah, so patent defect, what is it? A defect that is discoverable by a reasonable inspection or a reasonable inquiry. Now, these are some of the case laws which have come out over time that has some guidelines as to what is a patent defect. Something that you can see, is visible to the eye, discoverable by a trained home inspector. Not requiring any intrusive things such as digging out pavers, removing tiles, boring through walls or drywalls, getting through or lifting concrete or flooring, or things such as things that are fixed in order to find something that is wrong. And then there's no outward signs such as water or oil stains, cracks, drafts, things that you can smell or hear. You smell something bad, that gives you a sense of something's wrong. You see a little stain, that gives you a sense that there's a leak. You see a crack, and that means something wrong with the shifting of the foundation. And you hear and feel coldness in a room where it shouldn't feel cold. And then you think about drafts. So these are things that are reasonable. Anyone can actually feel or hear that could lead to an inquiry, that should lead to an inspection. And then the buyer beware principle applies. Okay. Well, the buyer should have known it, should have seen it. It could have asked about it, and could have seen it with a reasonable inspection, and therefore they can't use a patent defect to back out of a deal. Okay. Next slide. So there are some examples. Water stains, back up from the toilet when you flush in the toilet. Then the inspector comes in and flushes the toilet, backs up. Maybe there's something wrong. Cracks on the pavement, pooling of oil in the ground. Maybe there's an oil tank underneath and it's leaking or something. The smell of raw sewage. Maybe you have a property that is, serviced by a sewer or septic tank, etc. So, and then would lead to anyone to hey, maybe something wrong, and leads to some kind of investigation. Okay, next one. So then the whole thing is, well, what is a reasonable inspection? So how far do you have to go? And this is it can get every case is very how would you say, case specific and fact specific. So what is a reasonable inspection depends on the situation of the home. You're a house in the countryside, you're on a farm, you're in a rural area, you're in the city. So what is reasonable is really sometimes dependent on the circumstances. So, but just as a general guideline, nothing intrusive, nothing that has to be torn down or broken apart to look at. In this situation, the case that I gave you here, how do you find out whether a septic tank is actually in work or not? You can have a smell, but then you want to test it. How do you test it without taking the whole thing out to see if it's leaking or not? Well, there's some things that you can do, which is not that intrusive, like adding water to the tank and flushing the toilets and see whether something goes down or through, it doesn't back up. So anyways, that's one of the cases that gives that as an example. Next slide, Howard. Okay. And this leads back to the idea of feng shui. Is it difficult? No, not at all. Feng shui person comes, they're not going to do a lot of digging around, and they just see what it is and get a sense of where the chi is going, where the flow is. And they also, find out things such as the age and birth date of the occupants, and then find out where it's good for them to do certain activities in a certain part of the year. They don't have to do anything. They just have to see the situation. So in most situations, and I can't see otherwise, a feng shui inspection would be a reasonable inspection that could lead to something that is patent. It is not requiring anything digging up in order to find out. Now I have a case that could, like every, that's why lawyers are always in business. Wherever there's an A, there's a B, there's a pro, there's a con, there's a way to argue it, and there's a way to find a creative lawyer to argue something. And I have a case that'll show you something about that. But in generally, a patent defect, something revealed by a feng shui inspection will 99.99% be considered a patent defect, will not be a reason which allows the purchaser to back out, okay? If they find out something afterwards through a feng shui after subjects are removed. Okay, next slide. So, but what are latent defects? Now, in the law for BC, latent defects are not discoverable by reasonable inspection or inquiry. Whatever the defect they find has to make the property dangerous or uninhabitable, and which relate to a physical or intrinsic quality of that property that is measurable to an objective standard. So a latent defect can be discovered after subject removal. And if you discover it and it is a latent defect, meeting all our conditions, that is the reason and the ground upon which the buyer can back out, okay? And I'll give you some examples. If you go to the next slide. So not visible to the eye, these are some of the things, general guidelines. Requires more than an ordinary home inspection with specialized services, air quality sampling, coring and analysis of the soil, removal of the drywall, pavers, roofs, or tiles, or shingles. For example, mold, for example, you need a specialized inspection to test the air, and then you do bring it back to the lab, and then they come back, and then they tell you, sewer system and E. coli in the water, things that require something more than just the normal regular home inspections will allow, okay? Now, as technology improves, maybe those standards of what is a reasonable inspection will change. Like I've worked with, had the privilege of maybe a year and a half ago, 2 years ago, when marijuana became legalized. I did a lot of, you may have seen me at some of these other brokerages where we did presentations about latent defects, the new marijuana legislation, and things about marijuana and mold that quite often homes which have that, growing marijuana would end up having. But they require specialized technologies. It's extra additional expense and extra time upon which the companies that test mold has to come up with a result, because they have to get a sample in the inside, a sample on the outside. Then they have to figure out what type of mold it is, and there's all kinds of things. This is not a reasonable inspection. Technology may improve, but it's still not like somebody can just show up at the house and give you a report just by looking, smelling, looking, and seeing, okay? So next slide, Howard. So hey, I thought this was funny because this was an actual thing that someone says, hey, I bought a house. I didn't know there was a nude beach next door. And the guy was, the person was really offended by all these naked people running around the house in front of their house. This is, I think, in Lions Bay, I think. But the idea is that to one person, it could be, oh, I can't bear this. Oh, these ugly people running around. Maybe somebody different, but who knows? So they sued the seller and says that you didn't tell me that this house was by a nude beach, and you should have told me it's a latent defect. So, the idea is that this is too subjective. To one person, they may be offended, to the other person may not be. So that's not considered something that could be considered a latent defect. The person can say, hey, I can't live in this place. That's not the objective standard that someone's looking for. It's not an affront to someone's sensibilities in order for that to happen, okay? Next slide, Howard. So this is something that's very common, and not common, but very in the news and media. This is the case that happened not too long ago in Vancouver. In this case of Wang versus Xiao, where it was a stigmatized property and someone had been shot on the front steps of this home. And this is an important case to illustrate all the principles that I mentioned about what to put in the contract, what is important, what's not. And if you have time to read it, this is a very good case because it has a lot of things in it. And so some of the main things is that in this case, the purchaser had backed out of the contract after subjects have been removed. Because they found out the lady who was buying this case, which is Xiao, which is the defendant in this one, because the seller sued the buyer to try to force them to complete with the purchase. The seller was the wife of the late husband who had been shot right in front of the house. And then because of all the media surrounding that lady husband, her kids got kicked out of this West End school, and then the mother had to shop around to look for another school to live in, and she found a place out in West Vancouver and enrolled her kids in. And so the listing realtor was telling the buyers, of course, what the reason is that they're trying to sell the house. Oh, we're trying to move to another place for the kids to go to school. That's kind of like half truth and not really half. Maybe one of the reasons, is it the main reason? Is it the resulting reason? Is it a consequential reason? But whatever. The idea is that it was not disclosed to the buyer, and had the buyer had known, maybe they would have done something different. So the whole point of this was, if a stigmatized property and having someone die in the home is important, it's important for the buyer to actually put this in the contract and actually to make inquiries about this. Because the court in here, it was ruled in Supreme Court in favor of the seller, no, in favor of the buyer, because they're saying that the death should have been told, should have been known and made known to the buyer because, it's something important. And Court of Appeal overruled that by saying that it's too subjective. To some person, a death may not mean anything. So it's not objective enough of a term to put in, subjective to someone dying. It's not objective enough. And to automatically presume and allow a buyer to back out, it has to be put into the contract. Okay. Now, the idea about this situation is that the representation made to the buyer, had they led to a different reason. But what had found out, one of the key things about this case was the court says it was easily found out. It's a patent defect, because if you type in the address, boom, it was all over the news. The address, where it was, where it's located, who the member of the gang was. They didn't say the wife. They don't mention the wife, but at a trial, that was the evidence that was presented. Your Honor, it's not something you have to dig into the walls or you have to find out through police records to find out. You just Google it. Boom, it came out. It's reasonable inspection. Therefore, not a ground upon which you can call latent defect. It's a patent defect because it's easily found out. Okay. And that was a very interesting case because it has all these principles in subject conditions, backing out, half-truth, warranties. What did the seller's realtor say to the buyer's realtor? What did the seller actually tell the seller's realtor to tell the buyer's realtor? And is it different than what the seller actually knew? And did the seller's realtor even knew about the death? All these issues come up. So very fascinating. If you have time, yeah, go read it. So these are the stuff that I like, and I like reading cases, and it's just because that's me, right? But not everybody. I'll summarize it for you if you have a case. What does this mean? Let me know. Next slide, Howard. I want to talk about some of the things here. The death of Raymond Wang, which is the name of the guy that died with this shot, was not a latent defect, making the property dangerous or uninhabitable. Some of the arguments raised, well, look, this is a gang house now. All these people who were after him would come, and gang members would come, and who knows, they could be at crosshairs, and they're looking for him. Maybe there's retaliation or revenge. And so it wasn't enough of a latent defect to render it part of the physical or intrinsic qualities of the property to allow it to back out. Someone dying there is not an imperfection to the property itself. And then the idea was that it's because of the particular sensitivities of the buyer and not because of something in general. Not everybody would have that same reaction. And these are some of the fine points that allowed for that for the buyer not to be allowed to back out, and therefore it awarded in favor of the seller. Okay, next one. So a bad feng shui reading would not be considered a latent defect. A bad feng shui about assessment of home will also probably not render whatever it finds enough to consider to be a latent defect. Because although it may be intrinsic to the property, hey, the home is on the east side of the building of a row of buildings, or an apartment, or it's facing west, or you can't help it, it's facing west, or it's in a cul-de-sac and it's a T intersection. You can't change it. It's the way it is. It's intrinsic, but it may not be objective enough of a standard for anyone out there to consider it objectionable. Okay, so and then in the arguments that was made, they were saying, hey, the buyer is Chinese and Chinese are sensitive. It's not enough. It can't be ethnic specific, okay, without having it written down. Okay, next slide, Howard. So, but there's something different I want to point out. This is very important for all your agents. Is material latent defects. This is a unique term that's put into your manual, the Real Estate Council of BC Professional Standards Manual 513. Last time I checked, I think it was 513. It says material latent defect. It's different than latent defect. It's very important. It's one that cannot be discerned through a reasonable inspection of the property, but also, next screen, includes any of the following, besides the first two, which is the way the case law already says it for anyone else, but as well is unfit for the purpose for which the party is acquiring if the purpose has been made known to the licensee by the party. So in this scenario that I gave you earlier, the buyer went to the realtor and said, I want to make sure it's feng shui good. And the representation was made. And the licensee has otherwise became aware of the purpose. Well, the licensee was told about it. He was told about it and they know it. But it doesn't have to be told. They could have found out from other reasons, other ways, but they become aware of that purpose that the buyer wants it. Doesn't communicate it to the seller doesn't reply back. There's all these problems that could happen, and there's nothing that was represented to the buyer. Okay, next slide. So, and what are the other things that can consider ways to evaluate whether a defect that's discovered that should have been something told that the realtor know of? A defect that would involve a great expense to remedy, and this is the key. What if the feng shui says, well, you can't enter the house through the west, you have to enter through the east, and there's grass, trees, there's a boulder, there's a fence, and you have to build a driveway through the west side and remove it from the east. That's a lot of expense. So that can be a way in which they can say, look, the feng shui says I have to enter from the east, and it would cost me $30,000 or $40,000 or $50,000 to get in to go in from that direction. It can be considered a material latent defect. Okay. Now, who knows what the feng shui reading may say? And they say, hey, put a plant by the doorwell. Okay, that's like $5 at Superstore, right? So, but then here, and then C, circumstances that affects the real estate in respect of which the local government or local authority has given notice to the client indicating that the circumstance must be or should be remedied. So it's almost like, there was a zoning thing but nobody can tell by looking at the property that apparently they're not allowed to have children at childcare centers. And maybe the buyer said specifically to the real estate agent, I plan to have a home-based business looking after kids. And somehow, and then after they buy it, subject to remove, and they find out, hey, there's no zoning allowed for that. Oh, wow. And then you have all kinds of problems. If the sellers knew, ought have known, didn't say it, could have known it, didn't tell the buyers in specific reference to their specific condition on the property, or even if they don't, but you knew about it. And then, indeed, lack of a appropriate municipal building or other permits. Yeah, that's kind of similar to the same thing. Okay, next slide. So there's two kinds of disclosure. Like really, the buyers themselves, the sellers themselves, they only have an obligation really to, if there's a latent defect that makes the home harmful and unlivable or uninhabitable and unlivable, and they have to disclose it, and that's the reason for a buyer to back out. But agents have even greater responsibility because if they were told about something and then they knew that was the case, or they didn't make the inquiries about it and they should have known it. That makes the place dangerous or uninhabitable, but also all those other reasons that we just mentioned earlier. It takes great expense to fix. You knew the purpose and didn't, the purpose, and it was known to you. All those other reasons. Okay, so next slide. I just want to give us some other signs of examples of material latent defects. Rental suites are built without a city permit, oil tanks that were removed without a certificate of completion. And I just mentioned about daycare, but this is, say the buyer wants to open up a home-based bed and breakfast, that the zoning this allows it. And so, that's a couple of more examples. Next slide. So bad feng shui reading as a material latent defect. If the buyer makes specific inquiries of the importance of feng shui and the seller is aware of it and how important it is and knows it's bad but doesn't say anything, or they say that something is good when they know that it's bad, or and the had ordered a feng shui assessment and the master says you better sell this house or else, but nothing else, but didn't bother to tell the buyer that, and this could very well be a material latent defect, okay? And could be a misrepresentation on the material latent defect. And, and the seller can be sued as well as the licensee for that basis, okay? And if there is, if they kind of knew that the seller was really into feng shui, probably did an inspection but didn't bother to ask, didn't bother to read it, because hey, who can read these things and understand what it means? The buyer can back out and the buyer can sue, and there could be a lot of problems to the realtor as well. Okay, now next slide. So a little bit about this idea about willful blindness. A seller may say, I didn't know that was a problem, but maybe he really doesn't know. But based on the facts, and these are some situations they should have known, or probably knew, or more likely than not would have known, even though they say they didn't know. Okay, so there's lots of cases in the case law about willful blindness, and they should have known. So next slide. Some examples. A misrepresentation by a seller about drainage problems with the home. Even if the source of where the water came from was not in the home, but it was from a creek down the road, that every spring the water melts and water floods in, and it causes wetness and mold problems. The seller knew or ought to have known about the latent defect. Well, if the water goes into a house, is it likely to know that, and it comes in regularly, is it likely that there's mold in the house? Well, water, moisture, mold, wood, yes, it's likely. Like if you knew that it was regularly flooded, you should know that there's likely to be mold, and therefore that you could be having a problem. A latent defect could be found as a reason for the buyer to back out or to sue the seller for not showing or advising the buyer about that. In this situation, the seller honestly believed that he had fixed the drainage equipment, but was willfully blind to the continuation of the problem. I fixed it. I'm not going to look in that cabinet anymore. I put the thing on it. I put the washer in it. It should have worked. It didn't go bother to recheck, thinking that, oh yeah, I fixed it. I've done this hundreds of times. To stick in a washer, everything's good. Didn't bother to check. The seller's pumping out of all the excess water in this particular case that I mentioned here was made it a latent defect, even more latent. Okay, and this is the case that's interesting to read. It's an old case, but it's good for that example. A 1995 is provincial court case. Okay, next slide. So feng shui material latent defects. I wanted to talk about this case, Wang versus Sunset Point Estate. It's 1995. It's a long time ago, but it's important because it has a few things that are interesting. It never got to a trial. This was a summary application for an injunction for the builder. So Sunset Point Estates was the developer, and Wang was a buyer. And Wang, after they bought the property, they start digging into the ground. And then to build I don't know what they're building, maybe a swimming pool or something. And then they had a drainage pipe, and the drainage pipe ran across underneath the property about 20-30 feet across it, and drained the properties beside it, so that in all the properties and the adjacent properties would have water draining out but it was really deep underground. And then the buyer Wang says, hey, look, I had a feng shui reading that says I cannot have a water course on my property. Now everybody thinks river, creek, but who thinks about a drainage pipe 30 feet down on the ground as a water pipe, as a water course? It is water run through it, but nobody thinks of that. So they tried to use this as a reason to force the developer, seller, Sunset Point Estates to build another drainage around the property, so that it goes into, it does the purpose of drainage without going through the client's property. You know, it never got resolved, but this is very interesting because what the basically a 20-foot pipe underneath the ground is, you can't see it by reasonable inspection. You can't just walk around and see it. So it's not visible to the eye. You can't see moisture pooling on the ground, and it's most likely going to be, well, you know, underground. You can't see it. It's not subject to a reasonable inspection. It's therefore not latent defect. If you had a feng shui person come, they look around, I don't see that drainage pipe 30 feet under the ground. It's not able to have a reasonable inspection. Ergo, it's not a latent defect. But can it be a patent defect? Well, if you had to reorganize the whole entire pipe around the house and it cost you 30, 40, 50 grand to do it, yeah, well, maybe I'll say, remember that little section on the real estate, if they knew the purpose and it was item B, if they cost a lot of expense, it's expensive to fix or rectify. And but the only point, they never rule on these topics, but it would have been interesting about whether objectively it would render the place inhabitable, or perhaps dangerous to the person. Probably not, but it could fall under the other grounds for misrepresentation for material latent defects. Okay, but then ultimately this case wasn't decided on that. They said that, well, the buyer who bought the house dug into the ground and destroyed the pipes, and that's why they can't destroy the pipes and then tell the seller developer to fix it, because they broke it. They dug in and cracked it open and no water was able to flow out. So who knows what would have happened if they actually went to trial. But anyways, interesting case. This is the only one that I was able to find that deals with feng shui at a particular point. But it raises these topics that we're all talking about today. Okay. And anyways, if you have time, again, read the case. It's very interesting. If you want the link, of course, then you can ask Howard, or you can email me or text me. Hey, can you send me the send me the Word version of this PowerPoint, and then in it has hyperlinks. You can click it and get to the case. Or you can go to Canly, which is a free database for case law, CANLLI.org. Sorry, no, CANLII.org. Yeah. And type it out, and then type in Wang sunset feng shui, and then you get this case. Okay. Okay. Next slide. Yeah. So we finished that my topic dealing with material latent patent defects and objective subject conditions. So now Howard asked me to talk a little bit about the new Landowner Transparency Act. When that act came into force not too long ago, everybody was scrambling because on the day of November 30th, everybody had to figure out what forms to fill, what you need to fill or say for everybody when you register properties. And everybody's buyer who buying a home all of a sudden has to pay about 40, 50 bucks more because there's another registration that occurs at the land title office. And so the main point of this, now next screen, Howard, the points I want to talk about is why did they implement this act? It's so that it can be more transparent as to who actually owns the property. They don't want to have people who buy property on behalf of somebody else. If they don't know who that somebody else is, what their status is, are they Canadian? Do they have permanent residence? Do they have a SIN number, et cetera, et cetera. Okay. And ultimately, the information gathered is meant to help and facilitate enforcement offices such as CRA or Ministry of Finance to target people for fraud. Okay. Next slide. So you need to know a little bit about it. Date in effect last year, November 30th. Deadline for all people who own property in BC to report to the LTS, to the Land Title Registry, Landowner Transparency Registry, is November 30th this year. Even if you're not buying a house, you already bought a house last year. Before November 30th, you still have this time to require everybody to report it. Do you have a bare trustee? You're registered but not the real owner? The beneficial interest, which is the real ownership of the home, is held by somebody who's a company, and you have a nominee agreement between the developer and the person who actually owns title. All of that, they want everything to be revealed. And if you have a company, if it's held by a trust, like a family trust, you have to reveal who the beneficiaries are, the trustees, the directors, and shareholders. Now here, next slide. Now, if it's a company, that they need to know whoever owns at least 10% or more of the shares, because that's the idea is that if you have 1%, you're not going to have much control over the company. But 10% can be a make it or break it. Say someone else has 40% or 42, and combined with you, you'll vote all the time and be 52%. You have control, majority decision-making power. So the idea is 10% or more, and whoever has the power to elect the majority of the directors of the company is defined as who has power. So maybe you alone is 10, but with someone else together, your husband or wife together, you join it at 60. Well, you have power, you have to report. You can't say, hey, I only have 10%. I can't have any control, but it's not, just how much percentage, but if you have control over who gets voted in to be the directors. And for trusts, and who directs or controls the trustees, of course, majority decision making in the trustee. You can have 3 trustees where you say 2 out of the 3. Okay, any 2 of the 3, well, all of them have to be revealed. Partnerships as well. You can have 2 people, 1 person on title, but he has a partnership agreement or joint venture agreement with someone else who's a silent partner who puts in the money, but they have to reveal that as well. Okay, who has the right to 25% more or more of the property assets or the profits of that ownership, and who has the rights to approve or remove the majority of the partnership managers. You can, for example, have 3 or 4 companies. Each one of them appoints 1 or 2 directors. Each one puts different money into the project, and all of a sudden they have to figure out, based on their agreements, a partnership agreement, who has control, and then who appoints the people who run, like the managing partner of a partnership, like a group of limited partnership. Okay, next slide. So required information, what information is needed: name, citizenship, permanent residence status, date of birth, SIN numbers, and trust. You need to know who the person who put the money, the property into the trust, such as the settlor, who manages it, the trustees, and who are the beneficiaries. Corporations, you have to have the registered records office, the business number, and the name of the company. And partnership, if you registered a partnership, you can register it separate from a company. What type of partnership, and where's the registered headquarters, what jurisdiction is it? Because you can have an Alberta company owning the property here, a couple of companies which have different headquarters. So you have to reveal all of that. And then of course there's extra costs since November. I don't know if most other people, they include it as part of the package, but for myself, I do have a flat kind of rate, but based on disbursements that go on top. So if you add extra this, extra that, I have to include that on top. Okay, next slide. So a little bit about beneficial ownership: the person who actually owns the property but who is not registered. And that's what the registry, the landowner transparency register, is trying to get at. Who is not registered on the land title office, but who really owns the property. For example, like the shares there's an agreement where the shares are held by somebody else or run it, and by a silent partner and silent owner of the home. That's what they're trying to look at in people who have indirect control over something that's registered, like a company or land ownership. Okay, next slide. Beneficial ownership defined. There's many different ways in which someone who really owns the property can get the rights from, sometimes out of law. So like for example, marriage. So the husband owns a house, the wife, if they buy the house after they got married, the wife has in law and equity, by the Marriage Act, that Family Law Act as well, that they have an ownership, an ownership that can be, how would you say, they have presumptive 50% ownership. But it can be, disputed that, oh no, but I contributed this much, et cetera, et cetera. But there is a beneficial ownership as given by law. That doesn't happen by how much money you put into a property. Okay, next slide. And sometimes out of equity, which is, it's kind of like by custom, how would you say, or legal presumptions. Legal presumptions are done by case law. Legal presumptions are everywhere. For example, if a parent, an adult, gives a gift to a child, that's presumed to be a gift. But if an adult gives it to an adult, something, money, property, asset, it's presumed to be held by the other adult for the person giving it, unless something else shows that it's not. So that's a legal presumption. And equity is, the idea is like, there's all these kinds of rules. There is an act called the Law and Equity Act, which has a lot of these rules in there. But the idea is that if you were corrupt and your hands were dirty, and then you can't expect somebody to adhere or bind you to an agreement in which you were tricky in doing something to get that person to sign an agreement. That's equity. It's kind of like fairness. It's not fair for you to do this if you do this to someone else. There's all these kinds of presumptions in law and cases which deals with that principle. Okay, so if you stick in 100 grand and you verbally agree to someone, hey, that's my money, you listen to me, but your name is registered. And the idea is that, there's some things in equity which says that someone really owns something because it's their money versus someone who's registered and titled. There's all kinds of things that deals with that presumption. So, I just mentioned that the idea about an adult giving it to an adult or giving it to a child, that's one of those examples, okay? And when is a gift not a gift? You have to follow up with something if it's between adults to give it significant meaning to make it enforceable as a gift, okay? Next slide. So rights arising from agreements, which is different than by actions, fairness actions, or by presumptions of law, or by presumptions of getting married or not. And so there's co-ownership agreements. So two people own together a property, and in that agreement, they talk about who has rights to what, how they divide the profits, how they divide the expenses and the liabilities and the taxes, etc. A bare trust agreement where someone says, I can put my name on the property for someone else, and I can't do anything unless the person who really owns the property tells me what to do. A partnership agreement, kind of like a co-ownership, they're two business companies joining together. One person has the money, the other one has the contacts, the other person has the land. Joint venture agreement, very similar. Or shareholder agreement, you have a company that buys the land, but in between the shareholders, they have an agreement as to what happens and who gets what. Okay, next slide. And then there's a new thing in this Landowner Transparency Act, which they're trying to get at these things where people own other companies and company own other companies, and they're owned in trust by some other company that the directors are married to the directors of another company. So they have this phrase called control through a chain of intermediaries, which is meant to get at amalgamations of companies, interrelated companies, affiliated companies. So basically, at the end of the day, whoever can eventually control or have control over a director of a company that actually owns the property, no matter how many chains of interrelationships there is. Okay, so that's something new that's also brought up. And you can see that this is all in the effort by the BC government to crack down on laundering money and offshore ownership of properties. And it's quite very vast and expensive. And sometimes it's very complicated to figure out who owns what, who may eventually own what, okay? And all lawyers across BC are still trying to unravel it when they have a complicated inter-company kind of relationships. Okay, next slide. I think that's it. Yeah, thank you. And that's my presentation today. We can do, again, I'm going to show up my contact there. Yeah, that's it. Thank you very much.